Hi everyone. Today I'm going to talk about a few things you'll want to know. I wanted to talk more about the Citizenship Act that I've talked about previously. More specifically, the part that talks about criminal behavior and how that might impact your immigration journey. My name is Mejer. I'm an immigration attorney and an immigrant. I came to the US as a child. We overstayed our visas and I was lucky enough to get a green card through amnesty. I had to do that because the attorney my parents hired didn't do a darn thing. I don't want your immigration journey to be as long or as stressful as mine was, and that's why I do what I do. I share information about immigration to help make a confusing, complex, and slow system a little easier to understand. If there's something you'd like to know about, please post it below in the comments and we'll try to get to it as soon as we can. If you like this video, I'd really appreciate it if you share it with your friends. Don't forget to subscribe to our channel so you can see our videos when we post them. I talked before about the US Citizenship Act of 2021. This act is also known as USCA or the Biden bill. It was introduced by Senator Menendez in February, just a couple weeks ago. I shared about how this bill was designed to provide a pathway to citizenship for the 11 million undocumented people currently in the United States. One thing I didn't talk about is criminal aspects of this bill. The bill includes ways your criminal history may impact your ability to get legal status in the future. It encourages construction of a smart wall, and it adds more ways that you can be prosecuted and penalized under the law. But there are some good news. It redefines the term conviction for immigration purposes. It increases the number of petty offense exceptions, and it creates waivers for many grounds of inadmissibility and deportability. Basically, it allows you to ask for forgiveness for things that would otherwise make you ineligible. And it asks for the 3, 10, and permanent bars to be lifted. Those are, again, things that make you ineligible to achieve legal status in the US for either 3 years, 10 years, or permanently. So let's talk about this a minute. To receive status under the USCA, a person must not have a conviction for a crime involving moral turpitude. Now, this is a vague category that has no statutory definition. It really depends on case law and it depends on what part of the country you are in. But it includes minor criminal conduct like shoplifting. People don't know. If they come in, they plead guilty for having accidentally stolen something for $5, they pay a $100 fee. That's a crime of moral turpitude and has huge immigration consequences. So if you're applying under the USCA, you can't have a crime of moral turpitude. You also can't have any controlled substance conviction, which means possessing any illegal drug, which could include marijuana, even if it's legal in your state, like it now is in New Jersey. You can't have 2 or more convictions where you received an aggregate or in total of 5 years of jail. You can't have any trafficking conviction of a controlled substance. That means any crime involving the sale or the distribution of an illegal drug. You can't have any felony conviction under federal law. That means if you are convicted of a felony under state law, there needs to be an analysis of what that would be under federal law. Immigration is federal after all. If you're applying for the USCA, that's a federal bill, a federal statute, and you have to look at, well, what happened in the state case. You can't have 3 or more misdemeanors except simple possession of marijuana. Any marijuana offense that would not now be prosecutable under the state's law, not violent civil disobedience or minor traffic offenses. So you can't have 3 or more misdemeanors. However, a simple possession is not a problem, nor is non-violent civil disobedience or a minor traffic offense. Minor traffic offense might be driving without a license or driving with a suspended license. However, the DUI, even in states like New Jersey, is a traffic offense. That is not a minor offense. Lastly, you can't be deemed a security threat. The USCA permits a humanitarian waiver of a criminal turpitude, a drug conviction, and other criminal ineligibility issues. It also permits a waiver of the felony ground and the multiple conviction ground as long as the felony is not an aggravated felony under Immigration Naturalization Act, for example. Can't be for murder, rape, or sex abuse of a minor. And you can't have had any convictions during the 10 years before filing the application. Finally, the USCA permits a waiver of one misdemeanor if the person has no convictions for the 5 years prior to applying, or if you have two misdemeanors, you can't have had any of them for the 10 years before applying. They're redefining whether something is a crime or not, in some cases making it harder to be convicted of a crime than what presently is. And there are waivers for some things. So basically, this gives immigration discretion to decide, one, are you eligible? Because is it a crime or not? And if you are eligible, are you disqualified because of the crime? Maybe you are. And three, can you file for a waiver? So what does it mean, a redefinition of conviction for immigration purposes? And why should you care? Under current immigration law, the definition of conviction includes outcomes that would not count as convictions for criminal law, including alternative disposition programs. That's where you agree to a probationary period, and after successfully completion of that period, the charges are dismissed. Or an expungement that removes the conviction from your criminal background. Doesn't mean it didn't happen, only that it's not accessible by others. The USCA redefines conviction to exclude these rehabilitative forms of relief, bringing the immigration definition of a conviction more in line with the definition in the criminal immigration system. Prior to 1990, state and federal judges in criminal cases had the ability to issue what was called a judicial recommendation against removal, JRAC. The JRAC kept immigration authorities from deporting the person based on that specific conviction, even if it otherwise would have constituted a ground of removal. The USCIS restores JRAD, an important tool for reducing punitive consequences of convictions under current immigration law. Guys, this is a really big deal because often in the immigration context, the biggest problem, so when you're defending someone in a criminal case and that person is not a US citizen, the biggest problem often isn't where they're going to go in jail for a period of time. It's either they're going to be deported and separated from their family and never be allowed to come to the United States. So if you can handle both the immigration consequences as well as as well when you're defending the conviction, if you can handle both of them in the same case, well, it saves lots of aggravation and tens of thousands of dollars and years of litigation. The USCA also wants to allow more humanitarian waivers. Outside the legalization program, the USCA restores discretion to the Department of Homeland Security and to immigration judges to waive one or more ground of inadmissibility, excluding security grounds, and to waive one or more grounds of deportability, again, excluding a security or something like murder, rape, and sexual abuse of a minor. This waiver would helpfully narrow the grounds of mandatory deportation and mandatory detention. So what happens? Someone is convicted of a crime. Immigration says, well, that person is not allowed to be released. It doesn't give them bail, it doesn't give them bond. And they have almost no barrier to relief. Well, now they would have some barriers to relief and might be allowed to stay in the United States, and again, might be allowed to address both the deportability and any guilt in front of a criminal judge. It allows the immigration attorney to assist the criminal defense attorney while you're defending the criminal case, rather than trying to come in after the fact and perhaps having to reopen the criminal case to do what should have been done initially. The USCA suggests a repeal of all three bars currently in place: the 3-year bar, the 10-year bar, and the permanent bar. However, it still imposes bars to the return of people who have been ordered removed. So let me give you background. If you're inside the United States for 180 days and you leave, You cannot come back for 3 years unless you have a waiver. If you're in the US for more than 1 year, more than 365 days, and then you leave, you can't come back for 10 years unless you have been approved for a waiver. If you're in the US for 180 days or more without permission, you leave, and then you come back without a waiver, you are now subject to the permanent bar. So USCA suggests repealing these three. The bars suggested in the act, again, they vary in length depending on the circumstances, from 5 years to permanent. In the case of someone who has an aggravated felony conviction and was already deported, it might be 5 years, might be 10 years, might be 20 years. It also provides a waiver for these bars. The USCA authorizes DHS to appropriate funds for and deploy a smart technology strategy along the southern border. This means that they would use something like drones or other technologies to create a wall rather than using funds to build a physical barrier. The USCA also adds an additional ground to the United States Code, with penalizing someone with up to 15 years in prison if they, for profit or financial gain, quote, knowingly directs or participates in a scheme to cause 10 or more persons other than parent, spouse, sibling, son or daughter, or grandparent or grandchildren of the offender to enter or attempt to enter the United States unlawfully. Basically, what this means is if you're charging and for profit, you're smuggling people into the US that are not your relatives, you could have 15 years jail for that. This provision is extremely broad and has been weaponized to prosecute people providing humanitarian aid and exercising important First Amendment rights, so it is concerning to immigration advocates. This code, as it is right now, is being used against parents that are bringing their children to the US, or if I'm bringing in my brother or my grandparent or my uncle or my relative. I'm not doing it for profit. I'm not trying to bring lots of people, but I want to say help my relative come to the United States. Well, it's being used against me. This change is changing that. Again, none of this is the law. None of this may become law. I agree with some of the changes of the law and disagree with others. As this moves through Congress, I'm sure there will be a give and take on both sides of the aisle, and there will be some changes, and we will discuss it. Thanks so much for watching. We really appreciate all your likes, comments, and shares. Again, if you found value in this, please share it with your friends who may also learn more about U.S. immigration by watching this. Until next time, stay healthy and be well.